Well, let's move to the interview segment now. From script to screen, stage to studio, the entertainment industry is a wild ride, and when the stakes are high, the law gets interesting. Today, we explore entertainment law and intellectual property in Nigeria. We have a lawyer with us to discuss this. Charles Adeyoriju is a lawyer who attended the University of Lagos. Currently, he is a partner at a law firm called Charles Renshaw and Abraham, a Pan-African full-service dispute resolution and commercial law firm. And he joins us to discuss issues in Nigerian entertainment law and explore the gray areas of the industry. Charles stands as a distinguished legal advisor across the dynamic landscape of intellectual property, entertainment, and other commercial sectors. Charles, thank you so much for joining us at this point.
Thank you, Theophilus Banker. It's a pleasure to be on your show this morning. Thank you for having me.
Yes.
Coming.
All right. So we see that in the entertainment industry generally, when someone is signed, they hardly read the gray areas, and they just sign in, and it looks like they're signing their life away, their everything about them to a particular record label or to a particular studio and all of that. I'm sure you're concerned about this kind of issue. That's why you had to delve into the issue of entertainment law and intellectual property. How does this come to you?
Thank you, Theophilus, for that question. This is what we see every day in our practice of entertainment law. And what we see is that a carrot is dangled in the face of an up-and-coming artist in form of an advance. For instance, a record label approaches you, you're a fantastic talent. You know what, we can promote you, we can push you to the world. We'll push you out to $20,000. We'll give you a house in Ikoyi or in Lekki. We'll give you an SU. You understand? And the guy he doesn't even consider the terms, doesn't look at the dotted lines. He just signs off just like that. So what we usually advise is, look, before you take that carrot or before you are enticed into a record label, no matter how big it is, why not get an experienced practitioner, i.e. an entertainment lawyer, to consider the terms which you are about to sign. So there are a couple of factors, and let me give you an instance. When an artist is being approached by a record label, you can have a record label that is established, you can have one that is up and coming. Now, you have a record label that is established, offering you maybe $5,000 as an advance, and then you have a record label which is up and coming, offering you $50,000. At that point, what do? My advice usually is to go with a more established record label because they have proven themselves time and time again to be able to push an artist and make better of his career. And there are just so many clauses that you can look at. If you allow me, for instance, we've gone with the issue of advance. Another issue you have to look at is, what are your breakaway clauses? Have you negotiated those? And that's very important. When you get tired or something happens, how do you leave? Another issue is your release schedule. How is your music being promoted? What do you have to do to get your music out there per time? So a release schedule has to be properly negotiated. If it is not, then you find an artist struggling and being attached to a record label for very long. So there are the plethora of issues in that regard. But my advice generally is always to get the red lines always checked out by an expert, and you do very well.
So what are some of those hidden clauses that you would say would definitely come to you as a red flag in some of the contracts for either musicians or movie stars?
Okay, thank you, Banker. The very first one I always look at, other than your release clauses or breakaway clauses, is how long are you expected to be with this record label? That can come in form of ownership of your masters. So, you know, the intellectual work is, i.e. your music, for instance. When you record, when you translate your the product of your intellect into a format, maybe a music sheet, that document, that music sheet becomes property, your master becomes property of your record label. Now, how long is that record label supposed to hold on to that? Is there an opportunity for you to actually recover that masters from the record label in an event that you want to leave? Another very important one that people don't usually pay attention to is cost recovery. Now, for instance, the record label gives you $20,000 upfront to be recovered when revenue is being generated from the marketing or sale of your work. How does that record label recover? So, for instance, if your profit share is, say, 50-50. From what portion is the advance supposed to be recovered? Is it from the gross revenue or from your own portion of the revenue? That is very, very important. Because other than just producing music, I'm sure the artist is also in it for the pecuniary benefits, the money. So you don't want to be going home with less in the bag and your record label is going home with a larger bag than you are, even though you are the talent in this case. So those are just some of those clauses that one has to look out for. They are inexhaustible because when a record label drafts an agreement for an artist to sign, definitely more often than not, most of the clauses will be in favor drafted in favor of the record label.
Now, the rise of streaming services has brought a new, I would say, a new segment to entertainment law, I would say. So for people who want to put their songs or their movies on those platforms, what kind of legal advice would you give to such people?
So, the advent of streaming platforms has actually done more good to us. If you remember, in the times of past, in the early 90s when I was born, for instance, the only means of accessing music or videos, movies, was if you buy the physical CD, then take it on to play in a physical device, the CD player or DVD player. I know. But now with streaming platforms, you can access all of these materials with ease. What I would just say is you weigh the pros and cons. There's really nothing you can really do with streaming platforms because they provide a platform for you to put up your work. So you play by their rules and their policies. So one thing you have to ensure is that your work is original enough to pass the originality test. For instance, I know with YouTube, they have an intelligence structure that checks if your work, your beats might be similar to someone else's. And that is a grounds to bring your work down. What we also find with streaming platforms is that it has now opened the artist up to anybody just approaching the streaming platform to say, look, this person's sound is extremely similar, you get, to my sound. And more often than not, before even the streaming platform checks, they bring down your work. But we usually advise and we assist artists in that regard to negotiate through that challenge with the streaming platforms.
All right, so in all of this, now let's talk about piracy. Are we addressing piracy head-on? Because it's a hydra-headed monster that has always crept its head everywhere, and we seem to have no solution in sight.
Theophilus, the issue of piracy, I do not believe that you can ever 100% curb piracy. Is as good as saying that you can curb crime 100%. As you very well know, piracy is a crime in Nigeria. But I can say for sure that the extent of piracy has indeed reduced, thanks to, for instance, what Banker made reference to, the streaming platforms. Like I said earlier, before, your access to media content was by purchasing a physical CD. If you cannot get it from the main distributor in Alaba Market or in Oshodi, the only other access you have to it is the pirated copies. There are many videos and music that we listen to, even ourselves, that were pirated because that was the only form of access. Okay. But what we continue to do is to work with the Copyright Commission and to work with the pressure groups of the music industry and also the video industry to ensure that, look, the work that are being put out are protected. The bodies have to come together as one to checkmate all these pirates. These pirates go to one source to reproduce these works. If we go forcefully against all of these channels of reproduction, then I think we can reduce it even further. But that's currently where we stand.
So you talked about protecting the works of creatives. How can that be done? Especially when you look at the fact that, for instance, young and upcoming artists, they just dangle a particular, like you mentioned earlier, a house in Banana Island or in Lekki, an SUV and all of that, and 20 million naira just to sign a contract. And before you know it, they're sending their life away. How can such kinds of people protect their intellectual property such that when they ever leave the record label or whatever studio they have to work with, their works are intact and for them as well.
And I would like to also add to that question. For example, now Mohbad, who is resting in peace, now that he's gone, who is, according to law, going to inherit some of the proceeds that he's going to make from his songs?
Okay, fantastic questions. So let me go to the very first one. So I said, number one, you have to treat the product of your intellect as an asset. Intellectual property is an asset. It's a marketable asset. Just like you can have your house, and when you have your house, you have your title documents. You protect it against every intruder. And that's the way you're also supposed to protect your intellectual property. For instance, the Copyright Commission in Nigeria has an online registry. But it will shock you to note that many of your very popular A-list artists, when you do a public search, you cannot find their works on that registry. Which is very interesting, because the essence of that registry is to have your work listed. So anybody that wants to produce a work can go there on there, just like a trademark registry, and search, is there any work that is very similar to what I want to produce? And also, that registry also serves as prima facie evidence that, look, I registered first, because Nigeria, in many of our intellectual property states, we practice a first to register regime. So if you are not being proactive about protecting your intellectual property, then you always find yourself in a position where you have to contest ownership.
Okay.
So, like I said, always get good, credible advice from practitioners and let somebody walk you through the steps. Don't just get a document and just jump into signing. Now, Banke, to your question about how the longevity or who takes the right after an artist passes. It will interest you to note that, Banke, from the point when you reduce your music to a form, either in a sheet or in a CD, that material already has protection. Now, Nigeria is a party to what we call the Berne Convention, which is a convention which was designed by the European states early on in the years ago to protect intellectual property. And it states that, look, even after an artist is dead, the ownership and recognition of authorship still occurs to that artist even for as long as 50 years after his passing. Let me give you a very classic example. Sometime, I think in 2013, there was an issue between the estate of the late Marvin Gaye. You remember Marvin Gaye?
Yes, we do.
And a very beautiful song that was released by Robin Thicke, a collaboration of Robin Thicke and Pharrell Williams.
Pharrell Williams,
yes, it will interest you to note that when you listen to both songs, from the very beginning, they sound very similar. But the court went on to find, because the estate, which is the administration of the estate of late Marvin Gaye, challenged Pharrell Williams and Robin Thicke, and they went to court. And the result was that the court found that, look, the intellectual property and the rights of the late Marvin Gaye, which have now been devolved into his estate, have been indeed infringed and award damages in excess of $7 million, which is good money. That goes to you get
that song was blurred lines, and they got some from Marvin Gaye's got to give it up. Of course, it was about $5 million. Yeah.
Thank you. So that is good money for an estate to administer. So imagine distributing $5 million to the people you leave behind when you pass on. That's a lot of money. So, for instance, with Mohbad, for instance, trust me, that money could have done a lot for the family.
All right. So you earlier mentioned about getting advice from practitioners. Do we have a lot of people practicing entertainment law in Nigeria and all around the world? It might be in the US and all of that, but in Nigeria, do we have particularly people who understand entertainment law and who practice it for the benefit of creatives?
So first, I can tell you for a fact that Nigeria has some of the best talents, not just in music, but in the practice of law. Off the top of my head, I know at least 10 very, very, very sound entertainment lawyers. A number of them. There's one of them who has not only a degree in law, but has a master's in arts in law, and works for some of the A-list artists that you have. And across the scope of many top firms in Nigeria, you have experts, subject matter experts in entertainment law. One of the challenges that people might be affordability. But, even without approaching the big firms or the big shot entertainment lawyers, there are many other lawyers that have the capacity to assist artists in their music careers.
So,
all right.
You have practiced intellectual property for a while now. I want to ask, what are the issues that you have faced over the years, and what improvements do you think it needs to entail or bring right now?
Fantastic, Michael. This is a point that is very, very dear to me. And one of the challenges we've always faced is in enforcement. For you to be able to enforce your intellectual property rights in Nigeria, you are expected to approach a court, which is the Federal High Court in Nigeria. Now, when you enter into that space, then you fall into the space of general litigation, because we do not have specialized tribunals or courts, just like you have in tax cases, to adjudicate over matters around entertainment, copyrights, and trademarks. So you are left at the mercy of not only a court that is congested, but also with the fact that many of the judges are not subject matter experts in the area of entertainment law. What you usually have in other climates is that you have a specialized court or a specialized tribunals that can hear these matters expeditiously, even though many of them will still go to the general courts or general cause list of a court. But you can have a tribunal that can dispense with these matters easy. So if as a federation or as pressure groups for entertainers, they can advocate to have specialized courts or specialized tribunals, it will go a long way in the enforcement of intellectual property. Another issue we also have is the issue of record keeping. You cannot come to me now and say, look, I have the rights to this one, and you don't have anything to back it up. How am I supposed to fight for you? How am I supposed to approach the person that you allege is infringing on your rights? So those are some of the common issues that we have faced.
Okay.
And those proposed.
All right, so it's been interesting listening to you and getting your view on the situation and the issues in the entertainment industry when we talk about intellectual property and entertainment law. Of course, I actually enjoyed how you dissect everything. Thank you so much, Charles Adeyoriju, for talking to us and for giving us your insight. We will subsequently get to you to have further discussions on all of this. Thank you so much, Charles, for talking to us.
Thank you very much, Theophilus. Thank you very much for having me. It's been my pleasure.